Hi, I'm Joshua Houston, Advocacy Director for Texas Impact. I'm an attorney and a registered lobbyist, and this is a recap of the changes in Texas election law that were made by the 87th legislature. This presentation is not meant to be a comprehensive review of every facet of Senate Bill 1 and the half dozen other bills that passed, but rather we've picked the items that we think you, our membership, are likely to encounter as you help Texans vote in the upcoming 2022 primaries and the general election. We should note as we begin that this is January 14th, 2022. Unfortunately, we are talking about a rather dynamic area of the law for the next foreseeable future, with at least a half dozen court cases being litigated. It seems almost every week brings news that requires a change in this very presentation. To that end, which brings me to the necessary legal disclaimer. This presentation is intended for educational purposes regarding election laws in Texas. It should not be relied upon as legal advice or as having created an attorney-client relationship between you and Texas Impact. If you have specific legal questions, the services of a legal professional should be sought. The legal staff of Texas Impact would be happy to help with specific questions offline or refer you to another legal professional. To do that, please email us directly at josh@texasimpact.org. So let's dive right in. We're going to go chronologically through the process from registration to actually casting the ballot. And we are going to cover in this order, voter registration, voting by mail, voter rolls and purges, election administration, and finally, voter assistance. So this is a picture of the Secretary of State's website. So we don't want you to be confused. We want you to understand there is no online voter registration in Texas. Many states have it, we do not. However, if you are already registered to vote in Texas, you will now be able to update your existing registration online if you move to a different county. This was part of Senate Bill 1. There is supposed to be a website. We're told it's up, but we are struggling to find it. The state forwards your information to your old county of residence. The old county, takes you off their rolls and forwards your information to the new county. The new county will then process and register you to vote. It is our understanding that it will be on this page being votetexas.gov. Right here, you can see it on your screen. Again, and we should note there is ongoing litigation trying to force the state to do online registration. They clearly have the capability, just not the will. And it's been proven in a majority of states that do this, that online voter registration cuts down on clerical errors. And that's super important if you want accurate voter rolls. It cuts down on bad registrations. If Texas really wanted cleaner voter rolls, then Texas would do online voter registration. For voters who are newly registering to vote, the Secretary of State's information page that you see here does have an auto-populate function where it brings up a form and you can input your information. You can fill it out online, print it out, and send it in with a stamp, which we would recommend because obviously using your word processor takes the handwriting problems out of the equation and cuts down on the issues of a live person having to look at it and ascertain whether that's a B or a P or a whatnot when they go to input your information. Let's talk about changes, not really changes, but things on the voter registration, changes that make information on the voter registration form even more important than they used to be. So in hot off the press breaking news, in other words, just yesterday, election administrators from several counties announced that about half of the applications they've been receiving, the applications to vote by mail that they're receiving, they're having to reject them due to the new requirements of Senate Bill 1. We want you to understand why this is happening. There are two pieces of information on the form that Senate Bill 1 made super important if the voter later decides that the way they want to cast their ballot is by mail. First and foremost, Senate Bill 1 now requires an ID number on the application to vote by mail and then again on the carrier envelope that holds the official ballot. Senate Bill 1 did a rather nefarious thing. And we say, we rarely use that word nefarious when talking about legislation. Usually it's just dumb. But in this case, the legislature was repeatedly warned, repeatedly by lobbyists, by other advocacy organizations, by individual legislators, by legislative staff, and even the election administrators themselves went public in the press in Texas Monthly, saying this was going to be a problem. What the legislature could have done to prevent this problem is they could have set a driver's license number, state ID number, election ID number, or your social security number. This is what Georgia did. Instead, Texas went one step further. They said you must use either your driver's license number, your state ID number, or your election ID number if you have one. And only if you do not have one can you then use your social security number. In other words, they created a priority order. It is not one or the other. It's this one is the priority, and only if not, then the other. And so if you mess this up, if you do not use the priority order, then the election administrators must reject your application to vote by mail. If they don't reject your application to vote by mail, then they risk disenfranchising you because if they let your application through and don't catch it on the front end, then your ballot gets returned. The ballot board catches it on the back end, and then your ballot is in trouble. So better they catch it on the front end than the back end. But here's the problem. And here's why we're seeing so many of these get rejected. A couple of scenarios, for instances. I know people that turned 18. They did not get a driver's license at 16 because for whatever reason, getting your driver's license at 16 isn't the rite of passage it used to be. So they never got a driver's license. They registered to vote at 18. And then sometime in their 20s decided, okay, I need to get my driver's license after all. So in other words, their registration has their social security number, but now they have a state ID issued as a driver's license. They're going to have a discrepancy and they're in a legal conundrum. Another possibility, take my 98-year-old grandfather. He has the opposite issue. He has not driven in 20 years. His driver's license was issued in the 90s. It's 20 plus years old. Now, legally, you can use an expired license. That's okay. But somebody like him could easily look at this form right here, look at box number 9. And as I zoom in on it, looking real closely, it is not clear that this is going to happen to you on this form, especially if you filled it out in the 90s. But in this particular case, he may have filled a form out, filled a voter registration form like this out in 1995, for instance. He would have put in his driver's license number. But when he goes to annually apply to vote by mail, he could easily look at this and say, oh, well, I don't have a driver's license anymore. And he could put a social security number down instead. This would lead to him getting rejected by election administrators due to Senate Bill 1. And that is why these two examples are just a couple of examples as to why election administrators are having to reject so many of these applications this time around. Will this go to court? It seems almost inevitable, but litigation takes years. So in the meantime, if you are a person who helps folks register, stress that they put down a driver's license, state ID, or election ID number if they have one, and to keep using that same number if they vote by mail. Second, make sure the voter puts down their phone number. This is box number 8 right here. You'll note that it says optional, but if you are eligible and desire to vote by mail and something goes wrong, then that's how they're going to contact you to fix it. Senate Bill 1 created a process which you'll often hear people refer to as an opportunity to cure your ballot. It means you can fix some mistakes, but you can only if they're able to get in touch with you, which means you need to have your phone number. And if anywhere on the application to vote by mail, there's an opportunity to put an email address, put one down. Don't hide the ball on those things. Just put it all down. Don't leave any optional forms blank. Now let's talk about the applications. Let's talk about voting by mail specifically, and let's talk about the applications a little more. there is a lot of confusion about who can distribute it, when, and why, and a lot of fear. That's because right up until the last minute when Senate Bill 1 passed, private persons and organizations were included in a new criminal provision that regulates the distribution of applications to vote by mail. The last minute they were removed. So let's make sure we're real clear on this. Private persons and entities can distribute applications to vote by mail as they please. But for election administrators and maybe volunteer deputy registrars, they can only distribute the application if the voter requests it from them. They cannot solicit it either. So let's make sure we really understand what the law is for election administrators and volunteer deputy registrars. Let's look at the elements of the offense. A public official, and this is the key word, public official. A public official or election official, while acting in an official capacity, commits an offense if the official solicits or distributes an application to vote by mail to a person or from a person that did not request the application. I combined 1 and 2 here, but they are functionally the same. A third problem, a third offense, a third prohibited activity is if the election administrator expends public funds to facilitate a third-party distribution of the application. So we'll come back to this. That's very broad, a lot broader than you might think. And finally, and this is for election administrators and VDRs, if you cannot complete any portion of the application, you can't pre-fill or check any boxes, even if the person requests it. If you do any of those things, it's a state jail felony, not just a misdemeanor, but a big felony. Let's look at how this applies to election administrators. The election administrators are taking this very seriously. It's a felony, and the political climate is terrible for them. They are under constant accusation from the conspiracy-minded crowd and from those the conspiracy-minded crowd vote for. They're using their office to really badger these people hard. So, for example, the Bexar County election administrator has said, if a wife calls and says, well, I need one from my husband too, they are only giving one to the wife. The husband will need to separately call. How does this pertain to you and things you might do? So say you're one of our vote by mail captains and you are trying to make sure your Sunday school class has applications. They're all 65 plus, and you want to make sure they all have applications to vote by mail. The county's probably not going to give them to you. You're going to have to make your own copies. That's because making copies is the expenditure of public funds. It may be a few cents, but it doesn't matter. It is the expenditure of public funds that opens them up to a felony charge. They are unlikely to give you more than one application. You will need to get one application and make your own copies. Let's talk about how this applies to VDRs. And this is where it gets super confusing. And we will talk about a number of legal issues that have arisen. The fundamental legal question is this: are volunteer deputy registrars public officials? On the one hand, the V is for volunteer, right? And you may think, I'm not an employee, I didn't get elected. Surely not, right? Well, you are deputized as a VDR by a public official, an elected tax assessor who's also the county's voter registrar. Additionally, your job is regulated under subchapter B of the election code. Also, if you go look up case law, there is suggestive, again, nothing directly on point, but what lawyers call dicta, which means it's not legally binding on the court, but it is used to persuade a court when something's ambiguous. So Voting for America versus Stein, former Secretary of State, says, quote, a volunteer deputy registrar is an, quote, agent of the state. Starts to look like a public official. Again, if a court looks at what constitutes a public official under the First Amendment, in the First Amendment as defamation and slander cases, then it's a very broad definition of what's a public official. And there's a lot of cases on this. If you look to the state statute to say, well, maybe we don't intend this, there is no definitive definition in statute. You may be looking to case law to be to decide whether or not it's a public official. So if a VDR is a public official, then the same rules that apply to election administrators apply to VDRs. So you might think, is this gone to court? Yep, about a month ago. A separate case was filed, separate in the sense that it is separate from the larger issues being litigated in SB1. There's another court case that's consolidated all the SB1 cases. In this case, they've kind of pulled these issues out into a separate litigation. They did that, lawyers did that, hoping to speed things up, actually. So the two plaintiffs are an election administrator and a VDR. We are hoping, the request for relief, at least by the plaintiffs, I should say, is hoping for some sort of resolution by Valentine's Day of 2022. Whether that happens or not is beyond our control. It's up to a court, obviously. But we may get a look at what the state is thinking in their reply brief before February 14th, and that will be illuminated as well. Anyway, big point is stay tuned on this issue. We're hoping for clarity, and we're hoping for clarity sooner rather than later, but we're still in the hoping phase. Is there a workaround in the meantime? Well, maybe. We think there probably is. You got to be real careful. Let's look at subchapter E. The criminal offense, quote, does not apply if you are providing general information about voting by mail, or the vote by mail process, or the timelines to vote by mail. So it is probably, and I want to stress the word probably, we don't know, we don't have a court order, but it is probably general information if you say the following things. If you are a VDR and you say, quote, you know, if you want to vote by mail in Texas, then there's a separate form to apply, end quote. Now we say this because that to us looks a lot like the vote by mail process that you can talk about. Does not look like a solicitation. We think it's probably safe to say, oh, and don't forget, if you want to vote by mail in Texas, then it's due by this date. Well, again, that's general information about the timelines. We think that's probably okay too. Another option, a tactic that one church came up with that we think is a safe approach. They have two people at all times. One of the ministries they do, they're a university church here in Austin, Texas. They're by campus. They are working with college students, helping them deal with the issues that they face. And we're going to talk about those in a second. But their approach was to have two people, a VDR who can register you on the spot, and a non-VDR who can handle your applications to vote, your vote by mail issues. We think this is a pretty safe approach. It is also a very labor intensive approach. You have to double the size of your volunteer pool. Nevertheless, we think it's a one way to address it as well. And hopefully we get some clarity on this pretty soon. Let's talk about other issues in filling out the application. Make sure you do it in ink. You cannot use an e-signature. You cannot use a photocopy. If you are a person who likes to make copies and keep things on file that you've signed in your house, make sure you send the original. Do not send the copy. And again, we've talked about it with registration above, but don't leave any information blank on the application. Make sure you're using the exact same ID number that you used on your registration to the best of your knowledge. Make sure your email and phone number are listed. It's how they contact you if you need to cure. So I want to make sure one more time that we're super clear that we're talking about three different documents: your voter registration application, which is how you register, your application to vote by mail, which is a separate document, and finally, your carrier envelope that the mail-in ballot goes into. All three must have the same ID number and all three must match. We mentioned curing a ballot earlier. Fixing small clerical errors is what we mean by an opportunity to cure. Examples would be forgetting to sign your carrier envelope or this ID number issue we keep talking about. How will you be able to cure though? Well, I wish we had some better answers. It's a little unclear. In theory, there will be an online process. I say in theory because we haven't yet seen it. It's not entirely clear how how the state's online process is going to work with the prescribed process. It was a last minute amendment to allow it to be online. It was a good amendment. It was to help the disability community, but it wasn't well integrated with the larger prescribed process that was in the bill. What's the prescribed process? Well, if there's time, and we'll talk about what that means. If there's time, then the county will return it to you in the mail. If there's not time, then they're going to try to call or email you to get you to come in to fix it. But it's a little unclear what the proper amount of time is. Are they using the Postal Service standards? Is the county just deciding what they think is enough time, an adequate amount of time? Is this going to vary by county? We're not really sure. And if there's not time, they have to be able to get in contact with you. So make sure that information is available. Let's say you get this notice. You can cancel. What are your options? Well, you have three. One, you can cancel your mail-in ballot and go vote in person. You have to obviously do this on or before Election Day. Your second option is to go to the clerk's office and correct the defect. Now, the advantage is you have 6 extra days. The disadvantage is that you got to go to the clerk's office, and the clerk's office may be further away than your polling location. You'll have to decide that for yourself. And then finally, we hope that there's an online option, although we can't tell you much about it at this time. All three options have issues. And what I mean by that is you have to remember those that are voting by mail in Texas are senior citizens and the disabled, people that have mobility issues inherently to begin with. Online would be best for them, but in the case of my 98-year-old grandfather, he doesn't have email or internet at his house. There's accessibility issues. If you go in person to correct it, you do have 6 extra days, but you got that potentially extra travel to the county. And then finally, if you want to cancel and vote in person, that might be closer to home, but you got to make sure that gets done on or before Election Day. Voter roll purges. Let's talk a little bit about voter roll purges. The 87th legislature passed a number of bills, not just Senate Bill 1. Let's start with Senate Bill 1111. Senate Bill 1111 confuses two concepts. There's a concept of residence and a concept of domicile. It used to be that these two things were the same. We said residence means domicile in our code. And domicile means one's fixed place of habitation to which one intends to return after any temporary absence. Now let's think about college kids. I want to do the hypo first because this is really hard to follow. You're a college kid, you're away from home in College Station, you go to Texas A&M, you're an Aggie, and your parents live in Dallas. You know you're going to move every year. You know your residence won't stay the same. You don't really feel College Station is home. You really feel like Dallas is more home. You want to keep your registration in Dallas, but you're a new registrant. You never registered before. You could register in Dallas County previously, but let's look at what Senate Bill 1111 did. It added new language. It says a person may not designate a previous residence unless the person inhabits the place at the time of designation and intends to remain. Well, this college kid has a problem. It's September. They're at school. They're not at their parents' residence in Dallas. They're at school in Brazos County College Station. Let's look at what this bill is really doing. If it was a math problem, it's creating a circle. A is B, but now B is really A. Let's walk through this a little bit. So again, in Black's Law Dictionary, a residence is a fixed abode where one actually lives for the time being. Well, that would be College Station for our college student. Domicile is the place where the person intends eventually to return and remain. That would be Dallas County for our hypothetical college student. Let's compare the old law, which is still in the books. Domicile is where you intend to return. Intends to return envisions a voter temporarily absent at the time they register. The new part of the law says intends to remain, which envisions a voter present at the time of registration. These two things are not logically reconcilable. They are at odds. That's why we're saying Senate Bill 1111 is redefining domicile to mean residence, even though the code additionally defined residence to mean domicile. It is a circle. How do you resolve this? We're not sure. And of course, who does this most affect? College kids. But it also affects anyone who is mobile. So say you're a retiree who is sold their home and lives in an RV and is touring the country. Normal, I mean, that's a pretty American thing to do, isn't it? It would affect you. Are you an oil industry worker? It could affect you if you're temporarily away from your family or your domicile. It could affect anybody who doesn't have housing. So again, if you have a campus ministry or you are doing voter registration efforts with college students, our best advice is to use your current address. And this is a problem. We know it's a problem. We know that college kids will move. We know they will have to update every time they move. We know that many will forget to do it, which may very well be the point of this bill. And there may very well be a second potential motive behind this bill. And no one, of course, says these things out loud, but if you are a student and all students are registered at their university as opposed to their parents' house, it makes them easier to gerrymander. It takes them out of swing districts in suburbia and concentrates their registration around college campuses. So Senate Bill 1111 also makes registration very difficult for anyone who uses a commercial post office box. Who might use a commercial post office box that's now prohibited? Well, lots of people, especially those experiencing homelessness. So in theory, there is a process by which those without housing can preserve their registration. In reality, Senate Bill 1111 makes it so onerous, they'll never be able to comply. It's a lot like literacy tests. Only it's for the voter rolls, not when you actually show up at the polls. Here's how they're going to purge them from the rolls. Let's look at the new law. If the registrar has reason to believe that a commercial post office box does not correspond to a residence, then a confirmation notice is sent to that voter. Let's walk through how this is going to work and what we don't know about how it's going to work, frankly. It is not clear what constitutes a commercial P.O. box that does not correspond to a residence. First of all, remember the circular definition of residence. Residence is domicile, but a domicile is a residence. It's logically inconsistent. Second, how do you meet the new subsection F if you do not inhabit any place when you go to register? Can you use the church's physical address as a workaround? We're not sure. We kind of doubt it. Our stairs cannot be a place someone intends to remain when they crash there at night. It is not clear either what constitutes a reason to believe that triggers the voter registrar to send the confirmation notice in the first place. How will registrars implement this? There's a real potential for a lack of uniformity across counties. There's a real potential for an overly zealous registrar to really go nuts with these confirmation notices and start sending them out because they have a reason to believe it doesn't correspond. And ultimately, we think that's the point, is the confirmation notice. Because let's look at what the confirmation notice entails. You must reply to these confirmation notices or you are canceled. Under penalty of perjury, you have to then affirm in the confirmation notice that you meet the requirements for residency that we just discussed. The residency requirements that are really domicile, but domicile is really residence. Then on top of that, you have to produce a photocopy of your driver's license, your ID number, state ID number, your license to carry, or your appraisal district document, assuming you own property, your utility bill, assuming you have a house, or your vehicle registration, assuming you have a vehicle. Those things are a struggle for people experiencing homelessness. But assuming you've overcome the ID issue, you then need to have access to a printer. And if you do not have a permanent home, but you're using a nonprofit's mail service, on top of the access to the printer, you have to execute a sworn affidavit to accompany the confirmation notice. A sworn affidavit requires access to a word processor, access to a printer yet again. It requires access to a notary public. It then requires an ID for the notary public, and it requires knowledge of how to even execute a sworn affidavit. There are legislative staff who do not know how to execute a sworn affidavit. They've told me. I'm a lawyer. I've done it for them. Are there any exemptions? Why, yes. And exemptions are super interesting. They're super interesting for who they include, and they're super interesting for who they exclude. So who is included? Who does not have to do all these onerous things? The military doesn't. Witness protection folks don't. Judges don't. Police don't have to. Truck drivers don't have to. And college students don't have to if they live on campus. But they are excluded if they live off campus. And homeless people experiencing homelessness with a P.O. box at a nonprofit, they're excluded. Was this an oversight? No. Twice we tried to amend nonprofits into this bill. Twice it was rejected on the House floor. Can this be challenged in court? It already has been. The court case is Lulac versus Elfont. If you're curious, we are monitoring it closely. In the meantime, these requirements are so onerous, we really do not know how to advise nonprofits and homeless ministries on how to help their clients. Most of the time, you're dealing with Maslow's hierarchy of needs, and the first one is food, clothing, shelter. Voting, it does not fall in the very first hierarchy of needs. We're not sure how to help. If you're doing an ID ministry, you might consider helping out, but we're really not sure how you can even use the church's mail service if you provide that service, first of all. But if you provide that service, we're not even really sure how you can go about helping your clients when they get one of these notices. Let's talk more about purges. Big purges make big headlines, but do smaller, quicker, and frequent purges that happen every day. That seems to be the new strategy. You should watch Senate Bill 1113 real closely. What it does is if a county fails to perform a duty regarding voter registration, then the Secretary of State can punish them by withholding state funds. How will this be implemented? It's a question of we really don't know. We'll have to wait and see. But we're beginning to see. There are stories in Texas Monthly and a follow-up by the Texas Tribune that we're already seeing smaller, quicker, more frequent, constant every purges on a rolling basis. The Secretary of State is requiring county offices to check on people's citizenship status. And just like they did in the botched purge of 2019, they are using bad data. The Secretary of State has bad data that says, we think these people aren't citizens. And it turns out they are. We know this because naturalized citizens have said, wait a minute, I'm a naturalized citizen. I'm getting flagged erroneously. And when they get flagged, they get a confirmation notice sent to their house. Now, counties are trying to confirm people without sending the note before sending the confirmation notice, but in many cases they can't, which means like the homeless, they have to send a confirmation notice. And it's easy for people to miss in all the other junk mail you get in your mailbox. And if you miss it and don't return it, you get suspended. Here's how you can help voters watch. You can help people check their voter registration status online. You can't register online, but you can check online. And it's pretty easy. Here's where you check. If you want to pause the recording and take a look right here, that is the website where you can check yours or somebody else's voter registration status. Helping people do that and helping people navigate. People say, I'm registered. Yeah, they probably were. Check it anyway. Is there other legislation that's notable? Yeah, absolutely. Let's watch the implementation of House Bill 2283, forgive me. And 2283 prohibits private funding to counties for election administration without approval from the Secretary of State. Now, this isn't necessarily bad, but it could be implemented in a way that's nefarious. We'll have to watch. Does the Secretary of State approve foundation funding from conservative foundations to conservative counties, but disallow funding from liberal funders to more urban counties? We'll have to wait and see. We're going to have to watch it. The big question is, do counties have the resources they need, and resources meaning money, the funding they need to administer elections? How do you know? Well, it means we have to help. How do we help? We have to form relationships with our county election administrator. First step, do you even know who your county election administrator is? After you find out, you need to meet with the office at least. You need to find out what they need. The needs are going to vary by county. You have Loving County in Texas with 1,000 people and Harris County with more than 4 million. The needs are quite diverse, varying by county. There is one thing we know they all need, though, and we know this because their association tells us so. They all need poll workers or election workers. So let's talk a little bit about election workers. Why do elections work in Texas or anywhere else for that matter? Well, it's because of you. Texas has 10,000 polling locations. Each polling location has a presiding judge, an alternate judge, and 2 clerks. It's 4 people. 4 people per location is 40,000 people. And we're not even counting all the people hired to do, that's just election day. We're not counting the people hired to work the polls on early voting. We're not counting the people hired to do ballot by mail. We're not counting the central count. We're not counting the early voting ballot board. We're not counting signature verification committees or the county staff or the staff of the Secretary of State. What makes our elections free and fair? Our elections work because there are so many unrelated sets of eyes on every step of the process. We're talking over 100,000 eyes to make an election work in Texas. Let's talk about the roles of the election workers. You have the primary judge, the alternate judge, 2 clerks. The primary judge is from the party that won the race for governor. The alternate judge is from the other party. You have people of opposite parties working together to make that election work. Now, why are mainline Protestants, Jews, and Muslims, the membership of Texas Impact, why are we so important and critical to helping counties make elections work? Well, we're not politically homogenous. We are 50-42-8. We are 50% Democrat, 42% Republican, and 8% mixed. We are pervasive throughout the state. And in the more politically homogenous counties, the minority party often is not organized enough to provide a list of potential judges to the counties. So the counties are looking, and they're always looking to have alternate judges from the minority party. Our congregations provide the people to supplement those lists that come from the party. Let's talk about a few of the people you may encounter at the polls on election day and who they are. You have what you sometimes will use the term poll worker, sometimes election worker, and election judge. We are using these terms interchangeably. Now, these poll workers, election judges, they are employed by the county. They have authority over the polling location. They implement the election. A second category is poll watchers. They are partisan actors, frankly. They are appointed by the candidates or by the political parties. They are there to observe on behalf of the candidate or the party. That's whose interest they serve. The third category is poll monitors. Now, some of you may have done this. We have asked many of you to do this. They are part of the nonprofit sector. They are not in a polling location. They are 100 feet outside the no electioneering zone. They are serving as volunteers to be the eyes and ears of the Election Protection Coalition. They're there to ask questions and to ask you as you go to the parking lot, hey, how'd things go? What's going on in there? Did you have any problems? Is everything smooth? And if they begin to see something like people show up in the parking lot with guns, real life thing that happened, they call the Election Protection Hotline and let the Election Protection Coalition know. And the lawyers get involved at that point. So Senate Bill 1 created some very significant changes in these relationships, especially in the relationship of the election judge and the poll watcher. Senate Bill 1 empowered the partisan poll watchers and disempowered election judges. Let's talk about how that happened. So the powers of the presiding judge, before Senate Bill 1, and it's still true, the presiding judge shall preserve order, shall preserve peace, prevent breaches of the peace, and violations of the code in the polling location. A presiding judge has the power of a district judge to enforce order and preserve the peace, just like a judge in a courtroom. But the new law has made this more complicated. It has prevented presiding judges from removing a poll watcher unless the election worker personally observes behavior that violates the penal code. So in other words, a voter can't say, hey, this guy did this. The election judge has to personally see it. There are a number of problems with this provision. One of the biggest ones, not all disruptions are criminal. So for instance, you could have a poll watcher have a good faith dispute with the election judge. That dispute, that argument could take 15 minutes. Okay, once is probably in good faith, maybe even twice. But if it happens a third time, and a fourth time, and a fifth time, every one of those arguments sidelines a poll worker for 15 minutes, at least. If a poll worker is dealing with a poll watcher, then they aren't processing voters. That causes long lines, and long lines disenfranchise. And if poll watchers are targeting minority neighborhoods, as they said in Harris County they were going to do, there's video, then you begin to have even longer lines in minority neighborhoods that are notorious for long lines in the first place, with a population that disproportionately has shift jobs and less flexible jobs that is less able to wait in long lines. 2, election workers aren't penal code experts. This is law enforcement. This is lawyer territory. What are the elements of breaches of the peace? Well, that's an unfair question for an election judge. Third, they can call the police. Election judges can call the police to help them, and that protects the judge, but an armed police presence is intimidating for a lot of voters. And it's not a thing you want to have in a polling location. But there's more. The bill, Senate Bill 1, complicated a couple of concepts that are competing. You really can't reconcile these two things. Near enough to see and hear is one concept, and free movement around the polling location is another concept. So let's talk about these. A poll watcher is entitled to, quote, sit or stand near enough to see and hear the election observers. Okay. Are we using an objective or subjective standard? That's how a lawyer would say it in plain English. What we mean by that is an average person's ability to see and hear, or are we talking about that poll watcher's specific abilities to see and hear? Which one are they supposed to apply? Additionally, a watcher may not be denied free movement where election activity is occurring. Okay. Are there any boundaries or limits to that? For instance, how close can they get to a voter? Finally, if an election judge wrongfully excludes a poll watcher, what then? Senate Bill 1 created a new criminal offense that if a judge prevents a watcher from observing an activity or procedure the person knows the watcher is entitled to observe, including taking any action to obstruct the view of a watcher or distance the watcher from the activity in any manner that would make observation not reasonably effective, then that judge has committed a Class A misdemeanor. Here's the legal question. Is the wrongful removal of a watcher, quote, an action that distances the watcher from the activity? In other words, if you get it wrong, election judge, have you committed a crime? We think there's a strong argument for yes in the plain language of the bill. But here's the problem. Without clear standards for when a watcher may be removed, the election judge has to guess whether it was a rightful or a wrongful removal. And that exposes the election judge to a wide and unpredictable variety of prosecutions, potential prosecutions. Hopefully the operative word, and notice the word I've underlined here is knows. That's called, if you're like a lawyer, it's a mens rea requirement or a state of mind requirement. In plain English, here's what we think it means. We think it means that the election judge would have to know that they were entitled. So if there's ambiguity, how can you know? And we think this will protect the judge. It's why I would still be an election worker as an attorney. I would still do it. Plus, it's super critical to democracy, so I would do it out of duty, even if I wasn't an attorney. But again, voters and election judges deserve certainty, and this is unfair. And the ambiguity, the legal ambiguity, makes judges afraid, and that empowers bad actors to intimidate at the polls. Our final topic, voter assistance. The Voting Rights Act provides a voter a right to have an assister of the voter's choosing. However, Senate Bill 1 attempts to heavily regulate this activity. It requires now a form to be filled out, and it changes the oath that the assister will take. Okay, what's the big deal? What's so scary about a form? Well, forms precede investigations. The form is a name, an address, and the relationship to the voter. And let's be real. Now there's a record, and we know retaliations happen. The congressional record of the Voting Rights Act is replete with stories from South Texas of voters testifying under oath to Congress that there were economic repercussions that happened for even showing up to vote. And in this particular case, if your family is of mixed citizenship status, this could be really intimidating. There's now a record on a form. Local prosecutors and the Attorney General can begin to investigate you. And if they find that in your family is somebody who's not here legally, they can then report you to immigration federally, the federal authorities. Is all that really worth risking just to vote? A lot of people will decide it's not. A lot of citizens will decide it's not. Let's talk about the oath for a second, because it has the same problem. Under the previous oath, under the old law, it was allowed for a voter to ask their assister questions. So an example would be, a grandmother takes her granddaughter to the polls, both are citizens. And the grandmother asked, "Hey, who was that nice young woman running for judge that came by the house that we talked to last week?" Under the old law, that was fine. The assister could answer. Under the new law, that's illegal. An assister can only, in this new oath, swear that they can only read the ballot to the voter, direct the voter to read the ballot, mark the ballot, or direct the voter to mark the ballot. And remember, there are poll watchers lurking everywhere. People who are there for but one purpose, that is to report you. And in this case, they would report the assister for perjury of the oath. Now, maybe you aren't prosecuted, but the investigation itself in a mixed status family could turn up a family member that's not legally present. And now, is it worth risking that family member's deportation? Say, "Josh, we got to prevent fraud." Okay, there were already criminal statutes making unsavory behaviors by assisters super illegal. One, it was already illegal to mark another person's ballot without specific direction from the voter. There was already a fine law to prevent anything unsavory. There was another one. It was already illegal to influence the independent exercise of the vote of another. And Senate Bill 1 had a third provision that says it's illegal to cause the ballot not to reflect the intent of the voter. All of those laws were adequate before you went around messing with the forms and messing with the purge, with the oath. So we've reached the end. And we know, based on feedback from previous presentations, that this is dense material. Elections should be a cause for celebration, not for fear. If you have further questions that rewinding and listening again does not resolve, you can email us at josh@texasimpact.org. We look forward to working with you, and thank you for listening, and have a great day.